All rise. Judge Vanderbeek Court is now in session. Judge, this is case number JVB 1034, Thornton case.
Thank you.
You're welcome.
You all may be seated. Mr. Thornton,
Yes, ma'am.
you're back. How are you doing?
Oh, not as well as I'd like to.
Okay, all right. You brought this case before the court. What's going on?
Well, Your Honor, there's been some significant changes in my situation. And as you can see, Ms. Hernandez is not here today. And I have custody of the boy, and I have been, making our arrangement payments to her.
Okay.
Before we break down this intense courtroom battle, make sure you subscribe, like this video, and share it with someone who follows real courtroom drama. Now let's step inside. The bailiff calls the room to order as Judge Vonda takes the bench. Case JVB 103 is announced. Mr. Thorne stands up immediately. His voice carries frustration. He tells the court he's not doing as well as he'd like. That single sentence sets the tone. Something has shifted in his life, and today he's asking the court to fix it. But in family court, frustration alone is never enough.
But since the boy has come to stay with me, he's gotten himself into a lot of trouble.
Okay. What kind of trouble?
Well, he's been burglarizing some residents, and he was in an accident due to a police chase.
This is AJ, right?
Yes.
Okay.
And Ms. Hernandez refuses to acknowledge her responsibility to help me in covering some of these costs. I mean, the medical costs are quite extreme. My insurance is refusing to pay.
Mr. Thorne explains that the child now lives with him. Ms. Hernandez is absent from the courtroom. He insists he has stepped up, taken custody, and continued making financial arrangement payments. On paper, he sounds responsible. But then the tension rises. He says there have been significant changes. The judge listens carefully, flipping through prior mediation records. What was agreed before now becomes critical. Because in court, what you sign matters more than what you feel. And Mr. Thorne once agreed to something that now stands directly in his path.
Because it was a criminal act. In fact, they're probably going to drop me.
Okay.
And
If I remember correctly, you guys agreed to no child support during mediation.
yes, ma'am, we did.
Okay. And since that time, nothing has really changed with the living arrangement. AJ still lives with you,
Yes, ma'am.
and you still have not been paying child support. You've been making the back child support payments.
Yes, ma'am.
Okay. Other than AJ getting in trouble, what else has happened? Like, what has changed?
Well, she has moved out of state, quit her job, so her insurance no longer covers him
Okay.
in that aspect. And, the court costs, fines, and due to that accident.
Then the bombshell. AJ has been burglarizing homes. A police chase ends in a crash. Medical costs skyrocket. Insurance refuses to pay because the injuries stem from criminal activity. Worse, the policy might be dropped entirely. Mr. Thorne feels abandoned, claiming the mother refuses to help with mounting bills. But the judge reminds him, during mediation, both parents agreed to zero child support. AJ still lives with him. The living arrangement hasn't legally changed. The courtroom shifts from sympathy to legal analysis. One phrase dominates the discussion: material and substantial change.
There was a lot of damage in which he's liable for, or I am, and it's almost impossible
Okay.
for me to,
But AJ was double insured by both of you, right?
yes.
Okay. Here's the issue. In order to modify any type of child support situation, whether you receive child support or you don't receive child support, there has to be what's called a material and substantial change. That means that AJ's living arrangements would have had to have changed. Something about his educational expenses have changed. Something about mom's income would have had to have changed. But in you guys' case, you agreed in mediation to no child support.
Judge Vonda explains it clearly. To modify child support, there must be proof of a material and substantial change. A new residence, a significant income shift, a major educational expense difference. None of those apply. Yes, AJ's behavior created chaos. Yes, the financial burden is heavy. But legally, the structure of the agreement remains intact. Courts don't rewrite agreements. Because life becomes difficult. Mr. Thorne believed escalating costs would open the door. Instead, he learns that hardship without qualifying change does not meet the legal threshold.
So to go from no child support to receiving child support, you would have to fall in one of those categories for a material and substantial change. And based on what you said, you really don't fall into one of those.
That's very disappointing. So she's just free of any obligation? I mean,
Well, I wouldn't say she's necessarily free, but remember, you all did come to an agreement in mediation to no child support. So in order to start receiving child support, you would have to show that something has changed. So let's say, for instance, at the time of mediation, AJ still resided with her. Now he lives with you, then we can entertain child support at that point. But
The father pushes one final question. Is the mother free of responsibility? The judge responds carefully. She isn't automatically free, but the court cannot impose support without meeting legal standards. If AJ had moved after mediation, the case could reopen. If income drastically changed, it could qualify. But nothing legally shifted. The agreement still stands. The courtroom energy drops. Mr. Thorne realizes the outcome before it's spoken. The law prioritizes stability and signed agreements over emotional appeals, and today that principle works against him.
nothing has really changed since you guys have gone to mediation. Therefore, you wouldn't be entitled to receive any child support, unfortunately.
I understand. I mean, is there nothing I can do? Absolutely.
As far as I'm concerned, no, there's nothing you can do. Yeah.
All right. Thank you,
Okay,
Your
is
Honor.
there anything further?
No, ma'am. Not at this time.
Okay,
That's about it.
okay. Well, if there's nothing further, you're dismissed.
Thank you.
The ruling is final. No modification. No new child support order. Case dismissed. Mr. Thorne walks away without relief. This moment highlights how powerful mediation agreements truly are. A single decision made in the past can control the future, even during crisis. If you found this breakdown compelling, subscribe, like, and share for more real courtroom documentaries. Drop your thoughts below. Should financial hardship matter more than technical legal standards? And for brand sponsorship or collaborations, contact me at arhabshahid8@gmail.com. Until the next case, stay informed and stay sharp.